Okay, let's go on the record. Ms. Johnson, I think that you're there. You had 10 CI 0020 and 12 CI 00175 that you were asking for the firm to be relieved, draw as counsel. Is that correct?
Yes, that's correct, Your Honor.
Okay, well, I see that you submitted orders and I'll sign both of them. Okay?
Thank you very much.
Have a nice day.
Thank you too.
Porco propane versus one with others. Porco. You familiar with the ad?
You want to see your cross turn green and grow, use good work.
Yeah, it's Porco. You got a good judgment for citing that, so. What have you got, Mr. Carter?
Your Honor, we were here on the 7th of
Remember
December.
it just like it was yesterday.
I know you do. And the court at that time suggested we try to settle the overall matter, and we have not been able to do so. So I'm back here asking for the court to enter an order saying we can cash the $34,000 check and it won't settle the entire case. I think under the Morgan case, this is what we need to do. And I don't know if we'll ever collect a penny off of anybody else. We may not pursue it, but we don't want to be foreclosed from attempting to do that.
Your Honor, as far as the check and cashing the check goes, I don't know what argument to make on that one. If Mr. Cross wants to cash the check and proceed to try to get a judgment for the excess, I'm sure that we would raise the issue and say that by cashing it, they had accepted the payment. But I think that we're going to have an argument as to the finality of the payment of the $34,000, regardless of whether he cashes it or not. I think.
Well, that's why we're here, settle it now and not later.
Well, let me ask you something. What's your dispute with 34,000?
Your Honor, my dispute is that these funds were paid from the proceeds of a closing. Mr. Little, acting as the closing agent at that time, contacted Porco. From an agent of Porco, received this amount and was assured this was the payoff of the amount that was owed to them. So the check was written for that. So my client, Ms. Capp's client, both have reliance on that statement from Porco that that was the amount that was due to them. I think that would be our defense to anything.
If the amount had been $60,000 and that check was for $60,000, where would the additional $24,000 have come from? Who would have been entitled to those proceeds, and who has those proceeds now that wouldn't have had them if the $60,000?
Well, Your Honor, that was paid. I wasn't there for the closing. I'm assuming that was paid to the LLC as owner of the properties, and I'm not sure how it was distributed after that. I didn't have a part in the closing.
LLC? Did your client own?
My client was part owner of the LLC.
Was your client part
My
owner?
client was part
And
owner
who-
as well.
and-
Mr. Gibson's client was also part owner of the LLC, and I'm not sure where Mr. Gibson is.
And therein lies the issue too. Of course, I wasn't involved in the divorce action in representing Mr. Riddle because of a conflict, but the issue is, I don't know the time frame of how that agreement was signed, relieving her, Mr. Gibson's
Okay, well,
client.
see, this is neither here nor there, Porco. This agreement between these other
Yes.
parties.
But what I'm saying, Judge, is I don't know if that was signed in the course of the closing happening and that was the liability that addressed all of that because they had already gotten the amount from Porco. So that's why I think that aspect is relevant.
Well, do you have any case law that Porco, if they did get the wrong number, Porco did get the wrong number, that it extinguishes any debt over and above that?
Well, I mean, I think when you go
No,
to,
I don't want to know what you think. I want to know if you got any law on it.
well, there's law as far as the doctrine of estoppel and detrimental reliance.
And again, that's
What's
why,
the difference? I don't see how they would rely to their detriment on that if they receive the proceeds over and above that.
Well, but if they relied on the information from Porco that that was the amount that was due, and they allowed for those proceeds to be withheld from Mr. Little, who was the closing agent, then they assume that debt has been paid and they have relied on that. I mean, that's where the detrimental reliance comes in because they're relying on that closing agent to get the payoff from Porco, from the agent of Porco to provide the correct information for the closing.
Their action would be against Mr. Little then.
we're not going to pursue Mr. Little. He was in the dark. And the problem was they didn't keep Brett in the loop. They didn't keep anybody in the loop.
Well,
It's not his
I wouldn't
fault.
suggest that anybody proceeded against Mr. Little, but the fact that Mr. Little made a mistake should not keep Porco from collecting their money. I'm just wondering, go ahead.
Your Honor, if I could, I'm not sure that Mr. Little made a mistake. I think somebody from Porco might have made a mistake. But again, that's the
How do you
information.
know that?
Well, I don't know that for sure, Your Honor, but
I have to deal with for sure.
Mr. Little conveyed the information that was given to him from an agent of Porco, and I think Porco's bound by that number that they gave. And I would echo arguments made previously about how they detrimentally relied upon.
What's to their detriment? I don't understand. I mean, they owed the money. If they did owe the money, I don't know that they owed anything. I don't know that this is not the total amount. I don't know. I'm undecided. I hadn't made my decision. But the fact that someone gives you a wrong, if that money, if the proceeds had gone to another party, except the parties that owed the money, and therefore, because of their reliance, the money was not recoverable anymore because a third party had gotten and left it. I would buy into what you're saying.
Well, Your Honor, I think of it like this. If an individual were to go to purchase an automobile, and they were told the price for the car and they paid that. And then with whatever money they had left over, they spent that on their other needs or wants. And then the car company calls back a month later and says, we told you the wrong amount. You owe us X amount of dollars more. Isn't there detrimental reliance on the first number that was told to the
It could
individual?
be, but they were dealing directly with the car dealer and they had a deal on it. I don't think that's a good analogy. It's interesting, but I don't think it applies to this case, but I understand that. And if you had a direct deal with someone, you bought somebody and they said, oh, they didn't charge enough on a piece of land or anything else. But when you have someone that is a closing agent or something and calls somebody and finds out they're closing, I don't see how that creates a defense against the number being wrong from the person that allegedly provided the numbers to the closing agent. I don't know.
Judge, and I think by Mr. Cross's own admission, an employee, which is an agent for his clients, is the one that provided that information. I'm not saying we need to proceed.
Mr. Cross.
He did on the record in court.
Your Honor, Tracy Hay answered the phone for Mr. Little and looked on the computer and gave her a figure. That figure was what was simply on her computer. She hadn't been working there long. The difference in all of this, from what Brett's analogy is, and all of these people, we caught it in time. If we'd have cashed this check, I wouldn't be here today. It'd be too late, okay? But we caught it in time because it was an error. It was a mistake. So all we want to do is cash what we've got, and then we'll determine if we want to try to collect off 1, 2, or 3 of these defendants. Try to.
How much money is the deficiency?
It's to be determined.
Well, I mean, you can't come in here if you don't know.
Oh, I know, it's about $66,000 total.
More,
No, about 32,000.
32,000.
But as we said in open court last time, I think we would be happy to resolve the case for a whole lot less, but they don't want to pay.
What is a whole lot less? 10,000?
They won't pay.
Judge, I've spoken with my client. It was his understanding that Forco had provided them with that figure. And that's what he thought was the amount that was going to be paid. And he thought this was all resolved. So he's not.
He didn't know how much he owed.
No, because that's the other issue.
Who's involved in the management to make the decision of what they bought?
I guess that goes to both of the individuals running the LLC, which is no longer.
Who were
I
they?
think there was an issue with
The
administration.
individuals in the LLC, Your Honor, my client Joshua Renault and Ms. Cap's client Dwayne Riddle. I do think that Mr. Riddle probably handled more of the day-to-day operations because Mr. Renault is on the road a lot for work. I'm not saying anybody's.
So if I owed, if I owed somebody $66,000 during a close and they quoted 30-something thousand, and because they made a mistake even before they cashed the check, I'll be able to enrich myself and not pay them for the $30,000 based on that
No, but
reliance.
that's the other issue, Judge, is they continued to leave that account open and accruing interest once there was some type of agreed order as to what the amount would be for the sale of the property. So then I think you've got to follow the statutory limit on interest that's claimed as well, and we
How
still
much
don't know
is
that.
interest?
Oh, I'd say half of it. That's just an estimate. I have to figure it.
Your Honor, the other issue was at certain point, and this is nothing that was ever set in stone agreed on, but there have been discussions about being able to take care of this debt by paying the principal only on it at certain points. Again, there's no agreement to that, but that had been discussed. And
A
so,
lot of people would like to do that.
but, Your Honor, I do think that there was a reliance on the part of these gentlemen at this closing that the number they got from Porco was the final number.
Judge, as stated previously,
It's your client play five.
Brett and I were on the same common ground on this thing. He was supposed to let me know about the closing, and we were going to try to determine a figure to be owed. His people didn't tell him, and nobody told me, and nobody told Gary Little. So here we are.
To be frank with the court, I can't say I didn't know 100% about the closing, but I think I did find out the day before. And I already had obligations to be included.
And I can say I knew nothing about the closing.
So you're not gonna have to chip in on the money then?
No.
If we could just get an order allowing us to cash the check today, then we'll figure it
Well,
out.
yeah, well, here's the problem is that gets you out of it, but that doesn't help me any, to resolve the rest of it.
Well, Judge,
So I will tell you that and give me an order that you have preserved your issue as to whether acceptance of that check is payment in full or not, and go ahead and cash it, okay? Give me an order to that effect, and then we'll reserve. But I'm not saying ultimately I won't rule if that's not payment in full, but you could lose that way anyway. I'll just say that it will not be determinative in my finding on whether it's payment in full. You follow what I'm saying?
I understand what you're saying, but in the interest of economy, judicial economy, then if we don't know that we can collect any other monies on this, why would I want to try to spin my wheels and try to obtain a judgment against these people?
That's
I think
why I'm
we need-
asking y'all what the law is on it. I'm trying to determine. But I can't decide that here based upon facts that aren't really on the record, but just on arguments or no law. But I can tell you that you go ahead and cash that and it will not prejudice you in my decision concerning any delinquency in that account, okay?
Yeah, I do think under that Morgan case, we've handled it the way we're supposed to. We caught it, we come into court and say,
Well,
that's why we're asking.
that's the reason I'm telling you to do an order to allow you to cash the check without damaging your claim for the balance of the account you say is owned. And I'll let y'all take proof on it and submit it, or you can try it on a bench trial, or you can take it in front of a jury if you want to. I can't decide it. I've got no law except, these sort of things on detrimental reliance and estoppel. I mean,
So you,
maybe we ought to put the rule against perpetuities in there too, while we just can't get all those obscure things, okay?
I'll tender an order.
Make sure they see
I
it.
will.
Let Mr. Little see it too, so,
Mr. Little's not here. Mr. Little's not in the case.
okay.
So-
He's fortunate.
Judge.
Okay. Okay. Catherine versus Anderson.
Good afternoon, Your Honor.
Hello.
I'm standing in for Allison Adkins this afternoon. This is her motion, I believe, for review. The parties have previously been before you. And I believe my understanding was Ms. Anderson was to get one supervised visit per week as she's now attained sobriety, and the parties were to agree on a supervisor. The problem is they cannot seem to agree on a supervisor. There's been two proposals. One has been Ms. Anderson's mother, who is actually a social worker in Indiana. I'm unsure what the objection is to that. And the second proposal was her support person at the sober living facility where she's staying and receiving ongoing
Where you got,
services.
Mr. Cross?
Your Honor, my clients have been
You
reluctant.
move to the left, let Mr. Cross.
Yes, Your Honor.
My clients have been reluctant for the monitor or the supervisor to be someone who's so closely associated with Ms. Anderson. I believe the court probably just ought to go ahead and make a determination, and if that's satisfactory with you, I'll tell them to go by it. But particularly, we don't think it ought to
What's the
hurt
problem with
family.
her mother?
People said they've had great difficulty with her in the past. I have no details other than it's been a
Where
conflict.
would the visitation take place?
Your Honor, my understanding is Miss Anderson's mother is going to come down here to Clinton County, so that
Where?
visitation.
Where?
Any particular place in Albany?
Like the park or somewhere.
The park or some other
It's a little
location?
cold to be in the park.
Right, a public location,
Yeah.
library?
Yeah.
I can't see very much harm that could happen at the public library. Just go in there, just, and,
As long as it's a public place, I'll tell my people that that's just what.
I'd rather have it where some other people are around. You know, I'd rather have it like at the library.
You'll just let me look at it.
Yeah, certainly.
Okay, thank you very much.
Thank you, Your Honor.
Steve Bayer versus Gary Wallace and others.
So Mr. Wallen was filed that, we objected, and it's passed on February 8th.
White Herald versus Storm Resources. Hello.
Councilman Willis, the Attorney General's office, we filed the motion. I think it's by statute, we're allowed to intervene. That's the only thing.
We
that's
have
on
no
there.
objection, they're entitled.
Should just send me an agreed order, which y'all would have got to visit, have this great visit with each other. But you submitted an order
I did,
electronically.
Your Honor.
Okay, thank you very much.
Thanks.
Medical Center at, make sure I sign it later. Medical Center at Clinton County Inc. versus Journey Pure.
Morning, Judge. Afternoon, Judge.
Oh,
This is Journey Pure's motion, Judge. As you know, we've been here.
to reconsider.
This is not the motion to reconsider. We've been here a couple times on the motion to reconsider, the entry of order. This involves an emergency motion that we have filed, Judge, because they filed a judgment lien, on the order that the court is still not ruled on. And that judgment lien has caused our client to actually be in default on some of their other debts, and also has actually hindered us in even being able, if we were to resolve the case, to finance, to pay a lump sum because of this judgment lien. They filed the judgment lien, Judge, of record in Bowling Green that's attached now to all of our clients' property, and it's our position. This is not a final judgment. It didn't have the language of finality in it, that's made it final and appealable. Also, it had this motion to reconsider still pending, which makes it not a final judgment. We've submitted in our brief, Judge, some law, that clearly shows that, without a final judgment, you can't file a judgment lien and attach everybody's property. And, that is Duval versus Clay. And it dismissed and removed the judgment lien because there were pending motions, or motions for relief relating to the judgment that the lien was filed on. And this is our motion asking that this court,
Would you need to file some kind of bond if you wanted relief from execution?
not until it's a final, that you're referring, Judge, to the supersedious bond, that's on a final judgment and you file the notice of appeal, you have to file that bond under that rule. But this isn't a final judgment.
So and you might very well be correct, I'll reserve till I hear all argument, but let's say I file a judge, I sign a judgment. And then you come in and file a motion to reconsider and put it off to the next rule day. In the intervening time, you get rid of all your assets. Is that a problem? How would they be able to execute on anything if you could never file a lien if there was a motion to reconsider it?
Well, Judge, I think the law is clear.
Well, I mean,
You
I'm just
can't
asking.
file it, that at that point in time.
That's something the legislature need to take a look at, isn't it?
Maybe so.
They could never file.
It has to be a final judgment.
Well, I'm asking you, they could never file a lien as long as there's a motion to reconsider or anything or set aside.
I think the law is clear on
That's
that,
your position, okay.
that they cannot.
Go ahead. Country English.
It's, Lance, I don't want to. I'll move out, get it out of your way.
Judge, if a motion to reconsider is filed within 10 days under Rule 60.02, Mr. Turner's correct. There's nothing we can do. Got to wait till the court rules on that before we can do it. But that's not what happened in this case, Judge, and that's not the law in this case. They didn't, even though they were before the court at that time, they didn't file a motion under Rule 60.02. They filed a motion under Rule 62, which is a motion to reconsider the default judgment. Their motion to reconsider was not filed within 10 days of the date that the judgment was entered. Therefore, that judgment is final. We do have the right to proceed to file a judgment lien. The court admittedly could reconsider. If you set aside the default judgment, then and there is an order entered setting it aside, then yes, we may have to do something or release the lien. But by virtue of the fact that they didn't timely file that motion under 60.02, we have every right 10 days after the entry of that judgment to go ahead and file liens. And that's exactly what we've done. Judge, all we've done is filed a lien. They filed this motion today to hold me in contempt. Said I've committed a criminal act by filing this judgment lien. And you know, here we're in a situation where Journey Pure, after we have gone through time and time again, let them know of the lawsuit, let them know of the fact that we had this motion, served them with the motion for default, never showed up, never did anything. And then we come in here after all we do is file a judgment lien over and with the Warren County clerk. And they're claiming that I should be held in contempt and I don't know, Judge, put in jail or something.
Well, that could be true, but I don't think over this matter. What's your
Judge, his 10-day rule only, that is 59.05. That is a motion to alter, amend, and vacate that we do all the time after a jury trial or a judgment. That is where the 10-day rule comes in. It's 59.05 when there is a final judgment. We got to file it for 10 days. We got 10 days to file it. But this is not a final judgment. So that 59 and 59.05 only applies to final judgments. It clearly, the rule says a motion to alter, amend a judgment or to vacate and to enter a new one shall be served no later than 10 days after entry. And the rule specifically says final judgment. So 59.05 and that 10-day rule does not apply because this was not a final judgment. They are the one that prepared the order and sent it to you to sign. It did not say it was final and appealable. It had other parties in this suit that were not even served. So there's no way it is a final judgment under 59.05. That is why the motion was filed as a motion.
Those other parties can be jointly and severally liable for a judgment, what you're saying.
Absolutely.
Well,
and that's what they asked for.
So that doesn't preclude a judgment being effective again in full amount against any one of them, does it?
But it's not a final judgment under that rule because it doesn't deal with all the parties, all the parties, right?
You want to jump in this, brother?
This is very eloquent.
I'm enjoying a lot.
CR 54.01 defines judgment, what it is. It does not have to have the quote unquote final and appealable language. It says that a judgment is a written order adjudicating a claim in an action or proceeding. It said all right. It says a final and appealable judgment is a final adjudicating all the rights of all the parties. Now, as occurs Journey Pure Bowling Green LLC, we got a final judgment, Judge. We have it. If at this point in this proceeding we do, and we have every right to protect our interest. And that's all we're doing, Judge. We're not trying to sell property or anything else. We're just protecting the fact that this
If
court.
you go after any bank accounts or anything? or
No,
just go
sir.
after-
But they can, once they do that. But Judge, he's blurring the lines there. He read you the definition of what a judgment is. And then he went on to call it a final judgment. When the rule says that the lien, you can't just file a lien on a judgment. If you entered a summary judgment or something like that, unless it says file an appealable and adjudicates all the rights of all the parties, it is not a final judgment. And the rule on judgment liens only applies to a final judgment, that you can only file the lien because you don't want to run around and put a cloud on people's title when you don't have the final judgment, because just as he said, there's still a motion to reconsider pending. He's filed a judgment lien that has clouded all of our clients' property interest in.
How quickly did you file a motion to reconsider? How many days?
From the entry of
the judge,
of the written order,
of the judgment.
13.
So you missed 10 days, if the 10 days apply.
Obviously, I believe the 10 days don't apply. Yes, 13, it was 13 days after the judgment, but it wasn't a final judgment. And 5905 is a final judgment that kicks in the 10 days.
And the statute on judgment lien doesn't say that. It says that if you have a judgment, you can perfect it by noticing, filing the notice with the county clerk in the county where the property is located.
But the case law that we've submitted, Judge, defines that the judgment lien can only be filed on a final
And that's
judgment.
under a rule where they filed a motion to vacate, alter, or amend following the 10 days. That's what that case held, is that if you've got a motion to vacate, alter, or amend that was filed within the 10-day window, that I can't do anything. It would be inappropriate for me to file it. They filed it 13 days. Granted, this court can set aside a default judgment. I'm not saying that you can't, but having not filed it timely, I've got every right to protect the judgment that we have that's on a debt that these guys owe and haven't paid, Judge.
It's greatly disputed on the amount of, if anything, that we would owe. We also have to remember that this was filed really quickly after council was made aware of the entry of the judgment. And those motions were filed within days of council finding out. It was the discrepancy in regard to the clients and the client's misunderstanding. We've already argued that with the court. But Judge, I would once again say, the Duval case, which we have cited to you, which he says it was filed under Rule 59, the actual holding of the case says that where a judgment lien was dismissed by the Kentucky Court of Appeals in this case, when the lien was filed while a motion for relief from the judgment was pending. And that's exactly what is here. We had a motion to reconsider pending before the court when they filed their lien. And Duval, while it was filed under 5905, it was, Mr. English is correct there. The language of the court discusses that it's file a motion for relief from that judgment is pending, and before a court, you can't go file a judgment lien.
Judge, I
Well, I didn't set aside that lien, that judgment, the default judgment. Like, it was a default judgment.
Yes, sir.
In order to give your client an opportunity, in my own mind, to settle the case. They evidently don't want to settle the case.
Well, evidently they don't either.
Yeah, or somebody does, and I haven't heard whether there's any negotiations or anything.
We have negotiated.
Yeah, I don't know whether they're any closer to that, but I'm going, I hate to do an order overruling you on the motion to set aside, but I'm not inclined to set aside. And I would suggest probably that the next thing that's coming is either a judgment on the pleadings or a summary judgment motion on everybody else. I don't know where you are. You taking proof on any of these other defendants or?
No, sir. In fact, right now,
You think
There are-
you've got,
there are
you
many-
think you've got a lien
I-
on the people that
I
got the
think
money?
I've got the lien on the right entity
Yeah.
at this point, and I don't think, just that they have all these different corporate entities and that they're all the same.
Kind of shell companies?
I wouldn't, Mr. Carter's
Actually,
fine.
no.
There is a nationwide debate going on as to what a shell company is, right?
And I'm not going to argue that it's a shell company. I just think we've got a judgment lien. All we're doing is just trying to protect what's owed to us under a contract.
Well, I'm gonna overrule motion to set aside the default judgment and also say that because of that inclination of mine, I'm gonna say the lien is valid. So
Thank you,
just
Judge.
do an order and then I put final and appealable on that and you can take it up and you could have a case on that. Okay, thank you very much.
We'll get a judgment.
Thank you, Ron.
Yeah.
I'm going to bond, but.
McWhorter versus Hooker. I went to the DRC to.
This one to the DRC.
I don't know, what kind of motion you have? Was the other party present? Yeah, we'll make sure she knows.
They canceled school in Wayne County Friday and Monday. Yeah.
You think she knew, thought she was going down to the commissioner's office or what, anybody telling her? Is it your client's motion?
Yes, Your Honor.
Well, she was here earlier, so we'll continue to try to look around, send all points out on there. Something like that. Okay, we'll pass over.
That's fine, Judge. Thank you.
Laura Haddix and others versus Nancy Harden.
I've tendered a thought judgment and orders. I'm sorry, somebody's coming around it.
Give me a thumbnail for the record on this.
Your Honor, this is our motion. It's combined indivisibility action and a suit to enforce judgment liens. And we are, we'll just need to tender a judgment order of sale.
We tried to pay him several times and he will not take the money.
Okay, what's your name?
Nancy Harden,
Sorry, somebody called.
Nancy Harden.
Okay. Where do you, you are Nancy Harden and husband Ernest Harden?
Yes,
Yeah,
I have paid someone that.
yeah,
And
well,
I-
you need to speak up.
I have paid on that and I only owe just a little on that.
How much you trying to collect?
Your Honor,
Is this
it's
a-
far more complicated than Ms. Harden understands.
Um,
Number one, if I may, you
Move
have me
over
with
here just for a second and I'll let you come
Okay.
back.
Number one is the Haddix estate was owed money by Ms. Harden, and her sister. Her sister's paid her part. Ms. Harden has paid some. She's credited for all that. Number two, David Cross has a lien on Tony Albertson's part. I want my money. Number three, Stephanie Myers is joined it as a plaintiff and wants it sold for indivisibility. So there's nothing she can do to stop it.
Stephanie said you was shoving her to sell it.
Do what?
Stephanie said that he was shoving her to sell it.
Well, that's, then he.
And are you
he
allowed-
accomplished that then. So,
Are you allowed to,
am I allowed?
no,
Yes,
what I'm
I am.
saying? No, what I'm saying, if you file bankruptcy in federal court, is someone allowed to go in to your stuff and pull that out, your federal court, and put it in these papers?
I don't know what you're talking about.
I don't
I can't follow what you're saying. Did you file bankruptcy?
We did.
When?
It's been back probably 8 or 9
Was
years.
this debt discharged?
It was, but it's in this right here.
Well, I can't read that. It's got
I
a.
didn't go back that far. No.
The $11,000 we filed bankruptcy against, and it's in these papers.
I don't know what those papers are. I can't allow people to come up here and say, in this envelope, it's kind of like Karnak. It used to be on Johnny.
What, do
Carson.
you want to see
No,
it?
I don't really want to see it because I can't look at papers and interpret things for you. I mean, I just can't do that. Why don't you have an attorney?
Well, we've tried to get one and no one will go up against him.
Well, I can think of a
Said
lot
that
of
more
people.
often.
Yeah.
Wasn't any problem a while ago. Everybody else is up there against it.
Yeah.
Well, I mean, I've tried to pay him, and like I said, he won't have it.
We tried to pay him what?
What I owe
How
him,
much?
whatever he's
How much
asked,
did you try to pay him?
whatever he's asked for.
What do you want this woman to pay?
What? Let him tell
That
me
won't
what he
keep- Wait a
wants.
second. That won't keep the property from
No,
being
I
sold.
think Ms. Haddix is owed around $1,800 now. I'm not sure. We'd have to look at it. It's in the judgment.
But now the property be sold. This lady has an interest in the property, does she?
This lady has a third interest.
Thirty.
Her sister has a third interest.
Yeah.
Tony Alderson has a sixth interest. Stephanie Myers, Frank
So
Z's
the
daughter,
property,
has a
you don't want the property sold?
No, I don't,
Well,
because
but-
I promised my mama I would keep it on her
Well,
deathbed.
here's the problem is, that's a promise that would ultimately have to be broken by someone because every piece of property ultimately gets sold. Doesn't it? Sometime it'll be sold. And if there's one person that owns any of it now that wants to sell it, it's not, you haven't broken your promise.
Yes, but I've told him I will pay her for it. I'll pay her
Yeah,
for
but
whatever she wants.
Yeah, well, then you can buy it at the sale. And see, the thing about it is, if you buy it at the sale, you get your portion of it back. In other words, let's say it brought, what would it bring, Mr. Cross, piece of property?
Oh, it's hard. It might bring 15,000, it might bring 20, I don't know.
Okay, if it brought 15,000, if you bid 15,000, you get your $5,000 worth of it if you own a third of it. Follow what I'm saying?
Yes, but I don't want it sold.
Well, you can't keep it from being sold if one of the parties wants it sold. And I will tell you what happens if is it your sister that wants it sold? Is that who it is?
No, it's my
Her niece,
niece,
okay.
because he's shoving her to
Well,
death.
yeah, well, she says that now. But that's quite frequently what people say. Well, honey, I would never do it, but that lawyer forced me to do it.
I've
Well,
been
it's
through
not
this bus many
funny.
times. That's fine.
Do what?
I said, it's not funny.
Who's laughing? No, I don't think it's funny. It's sad, but it quite frequently happens. People say that lawyer made me do it. I've seen it happen. So I will,
I mean, I will pay whatever.
well, yeah, but you don't have a choice on jointly owned property. Mr. Cross,
Yes, Your Honor.
if this lady pays her debt, how much are you owed on it?
Oh, I think I'm over 2,500, 3,000.
Yeah, well, and this guy that owes you the money, the defendant that
I will
owes you.
pay Tony's part. We told him we would
Your Honor,
pay Tony's
if I may
part.
interject, if you knew how many times I've met with these people and how many promises.
I'm just trying to find out how much, what is
I
it
know,
gonna bring
and
up to sell?
I'm done. Okay,
Okay.
I'm done.
Okay, well, you're not done, until I tell you you're done,
Well, I
so
know.
just come back
As far as
around.
trying to work it.
See, now I'm trying to pay
Wait,
him.
wait, now, here's the thing about it, it's not your debt, it's the only thing that's involved here. That's not your debt. Now, if you got document that says you were discharged in bankruptcy from this debt, you should have filed an answer and say that this was discharged in bankruptcy. You've chosen not to get an attorney and not to file an answer. There's nothing in the file that you filed. Isn't that correct? You filed nothing. So I really don't have any choice but to sign the default judgment. I don't, but you can come, you'll be given plenty of notice of the sale of property and come to protect your interest in it. And Mr. Cross will probably be there and bid $2,500 or $30,000, whatever, to protect his land, right? So somebody else might be there, but I have no choice to do that, but to sign this.
Thank you, Ron.
Yeah. Thank you. Okay. DHRUVI 6 LLC.
Your Honor, Mr. Venters contacted me this morning, has filed an answer, so I will withdraw my motion for the default. That is it, his answer has been filed. I don't have any objection.
Okay, Cabinet versus Reggie Boff. Is that right? This is a child support case. What is this?
Judge, this is a divorce case that was transferred here from Rockcastle County in November of 2023.
I don't have a copy of the motion to file. Did you electronically?
Electronically filed it last Thursday.
That's the reason it didn't get in. We'll get a copy.
Judge, you can see my copy. It's a short motion.
Just tell me what it's about.
Judge, it's a motion for contempt. This is a case where there was a findings of fact, conclusions of law, and decree entered in June of 2013. So it's been more than 10 years. These parties have followed a time sharing schedule for the last 10 years, where she's primary residential custodian. He gets 3 weekends a month due to the distance between the parties. He simply has kept the child and not returned the child to start the spring school year in Clinton County. You know, the child's 15 and a half years old. He's missed the entire first week of school. He's filed nothing to get relief through the court. He's just told her that she's not bringing the child back.
Where does she live?
She lives here.
Where does Tony live?
He lives in Rockcastle County.
And does he enroll the child in Rockcastle County School?
He has, but if you read on the.
No, I'm not asking you what to read anything. I'm just asking you a simple
Yes,
question.
Dad.
Okay. Okay, I'd like you to swear your witness and just get some of it. You raise your right hand, man. Your right hand, your other right hand.
The other right hand.
Yeah, you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, you can inquire.
Ma'am, state your name for the record.
Gina Ball.
And Ms. Ball, did you go through a divorce case with Tony Ball in Rockcastle County in 2013?
Yes, I did.
And did that case go to a final hearing before the court?
Yes, I did.
And were you awarded primary residential custody of the child at that time?
Yes,
And is there only one child at issue?
yes.
What's the child's name?
Braden Ball,
And how old is Braden?
15
Turned 16 next summer?
in July.
Okay, so he's 15 and a half.
Yeah.
What is Mr. Ball's court ordered visitation that you all have followed for the last 10 and a half years?
He gets him the first, second, and third weekend of every month. He is to get him on holidays every other year. His are odd and mine is even. He got him this Christmas because it was an odd year on Christmas Day at lunchtime. He was supposed to return him one day.
Steve,
I'm sorry.
let's get down to what he hasn't done now.
He has not returned the child. He was supposed to return our son on Tuesday prior to school starting.
And he has failed to do so.
Yes,
And so the child's missed a week and a half of school.
yes,
Okay. And did your court order, grant joint custody between you and Mr. Ball?
yes,
And did it also say that if there was a dispute as to a major decision to be made, that your say would go?
yes,
And have you asked that he bring the child back?
yes,
And has he refused?
yes.
And what reason has he given you?
He says that, he has, rounds of showing physical and mental abuse, I believe.
And is this the first you've ever heard of anything like this?
Yes.
Has there ever been any criminal action filed against you?
No,
What did he say that the abuse was?
he did not tell me.
And is there also an issue with is he on some kind of medication?
Yes, Braden takes allergy shots once a week, and he also on Singulair and Zyrtec. And that has not been given to him.
What's his address?
Mr. Balls,
Yes,
612 Flat Pat Road, Berea, Kentucky.
Berea.
Yes, sir.
And are you asking the court to hold him in contempt of violation of the court's order?
Yes, sir.
And are you asking the court to order that the child be returned to you immediately?
Yes, please.
And you have concerns about the child's welfare and safety?
I do.
I think that's all the questions I have.
Child want to stay up there with his dad?
I think they're in the current situation, he's, convinced him to stay.
So the child has expressed to you that.
No,
How do you know that he wants to stay?
for text.
I can't hear anything with these doors closing or anything, you know.
I apologize, Judge.
No, it's
Through
not your
text.
fault. They just, these closures on these doors don't work like they used to. You know, they used to kind of go. Okay, who told you that he wants to stay up there beside your husband? You're the father, rather.
That's it.
So you hadn't had, the child, and you have not had a conversation about.
I have texted him and he has, I've got it on text showing that they. No,
What did he say to you, either text or calling or phone about staying up there?
He said that he was gonna, that I was to, go home and remain calm and that he
Who's
needed.
this, your son?
No, he was,
I want to know what your son told you about where he wanted to go to school.
is
Either by
not,
text or phone or email or whatever.
is not.
So you haven't had a conversation with the child about you're going to Rockcastle County, Mount Vernon School now? Do you want to
The
come
only
back?
conversation
Well, let
I've
me
had-
finish. You want to come back to Clinton County? Did you ask him that?
Yes,
What did he say?
he didn't reply.
Well, so he doesn't want to come back. Is that what you're saying? He doesn't want to come back?
I'm assuming, or he would be here.
What?
I would assume that.
How would he get here?
Well,
He
he was
can't
supposed to have been
drive.
returned.
Do what?
He was supposed to have been returned that
No, I'm
Tuesday.
talking about your son. If your son wanted to go to school here, how would he get here? He would call you to come get him, or does he have another relative that transport him?
His father would have to take them since he's.
And what if the father, and so you're assuming that the father just doesn't want to take him? So the son is undecided about where he wants to go to school?
I'm unaware of that. I can't answer something that I have not spoke with him about.
Have you spoken to the child at all since he didn't?
Through
come back? Let
text.
me finish my question. Is that okay if I finish my
Yes, sir.
sentence? Have you spoken to the child at all about anything since he didn't return on the date he was supposed to?
It has been very brief and very little, sir.
The answer to that would be yes.
Yes,
Okay. Now, this is how you and I are going to get through this. I ask a question, you respond directly to it, okay? So you have spoken to him. And what did he say to you? He didn't mention at all that he wasn't back or he wasn't coming back or wanted to stay up there. He didn't mention anything about it. The little boy.
no, sir.
Yeah. Did you ask him?
Yes.
And he just was silent, correct?
His reply was, Mom, I love you most of the time, or sending a heart emoji or something to that, or I'll see you soon.
You have anything else?
No, Your Honor, Not as far as questioning, no. No, I
And
would
now
just
you want to
simply.
make an argument?
Yeah, Judge, I mean, as your Honor's well aware, I mean, there's ways to go about modifying time shared custody, and the way to go about it's not unilateral defiance of.
Well, I'm thinking that you're entitled to a contempt order. I don't necessarily think it's the best thing to do, but you're entitled to it. There's something else we're not hearing here. I cannot believe that this lady has not had a conversation with that child or the child won't respond. I'm not saying you're not telling the truth. I'm just saying it's hard for me to believe that the child, if he wanted to come back, wouldn't have said something that he wanted to come back, or I'm happy here. Then he said nothing. I'm not saying that didn't happen, okay? It's very unusual that it didn't happen. When you contact him and say, where are you, Junior? Why aren't you here? And he doesn't say anything about I love you. So I don't know if he did, but we will find out, I would say, when you get an order and have him to immediately return the child. You give him till in 24 hours from the day he served with this order to get the child back here. Or he should be found in contempt of court, in order to spend 60 days in jail.
Judge, I'll draft an order and tender it.
Okay. Now, if I find out you're not being completely candid with me, it's not gonna be good when I make the ultimate decision. There'll have to be other hearings about this at some juncture, because there's some problem here. I don't know what it is. It's his perception of how you're treating the child, which might be all wrong. Okay, or it's the child's perception of how he's being treated anyway. I want to talk to you about it. That's the reason it's more complicated. You're entitled to this order. I don't necessarily think it's the best way to go. If you send him a warning letter to bring the child back or give him any other notice other than this motion?
No, Judge, she came to meet with me Thursday, and that was the deadline to file.
Well, you know, you might very well get the order to me today. And then I would attempt to make some contact with him and tell him to have the kid back down here tomorrow and have him in school.
And I can definitely have her relay that text message.
Well, I don't
whatever I can
really,
do.
I don't really want her to have to relay that to her child. I don't want her to be the one that tells the child he has to come home.
No, I meant to.
I know,
the dad.
but that's the way it will be perceived by the father. Your mother called up here and said, I have to bring him back. He needs to get a court order from me. And hopefully it won't harm whatever kind of problem you've got with your child. And you got some kind of problem with the child. There's some kind of problem there. I don't know what it is. I hadn't heard it yet, but it's there. Okay, thank you very much.
Thank you, Judge.
Okay, what else do we have on the docket? Yeah, the bathroom, Leigh went to the bathroom. There's,
Yes, my client stepped out, Your Honor.
she gonna step back in?
She's returned.
Okay, have her come around. I love that. Okay, now this is one that we were gonna send down to the Domestic Relations Commissioner.
That was my understanding, Your Honor.
Okay, but let me, before we go down there, see if there's some accord that can be reached. It's not been a day of great accord. Who's got the problem here?
Judge, it's our motion. He hasn't seen his little boy in a year. And he's filed a motion for relief for it because
What's the problem?
Your Honor, the
I'm
problem.
not gonna take any proof. The commissioner will take the proof. Can't work it out.
I understand. What we would say the issue is there was an incident which led to Mr. McWhorter not seeing the child, which was him shooting at my client's belongings, including a Bible,
You doing what?
shooting my client's belongings, including her Bible, urinating on her possessions, including a childhood heirloom, presumably that would have been passed to their child, and committing domestic violence. So that is what
You
has
get
led.
a DVO on him?
Yes, she has a
Still
DVO.
in place?
It is, Your Honor.
What does it call for? It's for solicitation.
It did not address custody or visitation at all, and Mr. Garman had filed this action. We filed our response back in August. I had expected him to file some kind of temporary motion, but he's done that now. So my client still has concerns that Mr. McWhorter has not addressed his anger problems and has some concerns with his mental state that he would shoot someone's Bible, urinate on all of their belongings.
Well, I have a
So-
lot of concerns about shooting the Bible. You know, most of them would be, long-term sort of thing. I'm not saying he did shoot the Bible. So. Well, it sounds like y'all need to go take some testimony. Have you talked to the commissioner?
I have, Your Honor. He
When
indicated,
can he set a hearing?
that's what he was gonna have us address once Mr. Garman was finished over here.
Okay, well, y'all get on down.
Thank you,
Thank
Judge.
you, Your Honor.
Orton versus Orton. What do we have here?
Judge, we were here previously and we had entered an order where he would receive visitation with the three children, 1 hour per week supervised by her aunt. And in the order, we had listed that it would be reviewed today.
Yeah, see that.
We are asking that there be no additional visits at this time. And the aunt is willing to continue for another period of time to supervise.
What do you mean, no additional visit?
No additional visits.
Discontinue, that the visitation as it's now in place continue?
Yes, that it continue, but
So
no
when you say-
additional.
Well, when you say that there be no visitation, you could take that as you don't want him to have any visitation. But so you want the temporary visitation schedule to continue for how long?
To stay in place, at least maybe 3 or 4 months. I know Mr. Orton is in drug court and we don't know how long he's gonna be in drug court or the status of
Okay,
that.
how the visitation's going?
You wanna hear from my client or
Yeah, I'd
myself?
like to swear to raise your right hand, please. Swear the testimony best gives the truth, whole truth, and nothing but the truth.
Wait.
You get on her side over here. You get on her side. You get in the middle. State your name, please.
Hey there, Danielle Orton.
Okay, go ahead.
The visits are going well, I think. He missed this week's visit, which he said he was sick, so that was fine. I agree with that. The kids don't need to be around that. They're supposed to do it tonight, I think. He missed the first one, but I think it was like communication error there. But other than that, it's going good, but I have concerns with some stuff that he's posting on social media.
Like what? Just tell me. No, just tell me.
He gave the kids a phone the last time he was here. The kids have the phone. I have to make them call him, but yet he wants to accuse me of not letting them call him. I'm good with whatever they want to do. He posted something about if people don't quit pushing him, then he's gonna get that IDGAF mindset back. And people's
Gonna
not
get
gonna
what?
like the, it's, I don't give a mindset, and he doesn't care pretty much who it makes mad. Yeah, people wouldn't like the outcome.
Post that on Facebook or where?
Yes, it's on Facebook.
You have a copy of it?
I do.
Sure. You know.
That was just 2 days ago. 2 to 3 days ago.
know.
Yeah, great. I just want to give you.
It had nothing to.
Wait a second. Okay, go ahead. Introduce that as exhibit number 1. For the petition. Go ahead.
The kids enjoy seeing them, I think, but they don't, I have to make them go.
How old are they now?
7, 9, and 12.
Okay, anything else?
Does your oldest daughter create more of a problem in making her go?
She fusses about it, but I know she loves them.
She's 12.
She's good.
I'd say she'd be fussing about everything at 12.
She's got her days.
I just have one other question. Has your aunt reported any other observations in the most recent visit about his interaction or inability to
said-
interact?
I don't know if it's this past time or the time before, but said he was on his phone quite a bit, but other than that, there's not been nothing bad. Said,
Now, do you have any questions you'd ask her? I'm gonna let you, I'm gonna let you testify yourself. Wait. But you can ask her questions now. You can't testify. Put her back in the center here. Put her back there. Okay. You can ask her questions now, and then later you will get to testify. So I don't want you testifying now. Is there any question that you want to ask her now?
Yes,
Okay, go ahead.
last night when we had our phone call, when they called, Tessa, the oldest from the 12-year-old.
You're testifying. Ask her a question.
Did she not say she would like to see me more on the phone?
I don't listen to your conversations.
Okay.
They go in the bedroom and I'll go to
Do
the
you have
living
any
room.
other questions?
Yes. You say you don't listen to our conversations, but you've actually chimed in about the stuff with the Christmas presents and
When you,
stuff. When I was actually.
Wait. I told you to ask her a question. You'll get to testify in a minute, okay? You can ask her a question. Have you intervened in phone calls we've had? Have you talked? You asked her that question. That's a question, but you can't just take off like this. I'm not gonna have a fussing contest here.
he asked the kids what size they wore. They didn't know. I told them the sizes, they told him.
Okay, now you have any other questions?
No, sir.
Well, okay, now do you have any redirect?
Just one question. Do you feel that the current visitation should continue as it is now for a period of time, as long as your aunt will supervise it?
Okay, here's the thing about it. It's important to have testimony on how somebody feels. She probably feels a lot of things. He probably feels things, but I don't rule on what people feel. If she has any reason why the visitation ought to stay the way it is, or whether it should expand. Now, I call it back up for review. There's no motion here to expand it. We're just reviewing it right now. He needs, as always, needed to lawyer up, which he's never done, if he wants to expand his visitation, okay? So if you want to ask her any other questions, it might give me any reason why I shouldn't expand it or why it should be limited, okay?
Do you feel that it's in the children's best interest that there be more visitation?
Okay, I know that what she feels about that. Okay, thank you. Okay, now you can come over here. You come over there, you raise your right hand. Swear the testimony you're about to give us the truth, the whole truth, and nothing but the truth.
Yes, sir.
Go ahead.
Your Honor, I have my drug court. I will be in phase 4, February the 4th or 5th. I'm not exactly sure. No failed drug tests, no failed meetings, always going to my Donna. I've not done anything wrong. I show up, I've tested positive for strep, so I'm just so fair warned. Just like our aunt also missed a meeting and said, hey, can we do it on Thursday? I was over here coughing a while ago. I'm sick.
Well, I'm not impressed by the couple of times you've done this, so don't be coughing.
I know, I'm sorry. The thing on Facebook, Barry Cross is already addressed. It had nothing to do with anything else
It's
other
not
than me
very
getting.
smart to put something like that on.
I was getting threatened for my life.
Well, here's the thing about it is, if you're getting threatened for your life, you ought to go to law enforcement or somebody
has-
else. Because anybody that has any kind of problems, you can take a look at that and use it against you later if something happened to it.
Barry Cross, like I said, addressed that I can't take it to the law here at being family. There's a lot
Yeah,
to
you
this.
can. You can take it to anybody. You can make a complaint to anybody, whether they're family or whatever. You go to the sheriff's department or you go to the county attorney and file a complaint. Go to the county attorney and file a complaint. So,
Your Honor, last night when I was even on the phone call with him, and I've asked him several times, I'm not asking for overnights, but I would like to be able to. I'm not going to keep them. I love my kids
okay,
dearly.
well, here's the problem. I'm gonna allow you to at least keep what you have now. This is not gonna be limited, but you need to get somebody to file a motion for you. Okay,
Yes.
it appears to me that you have made progress in this drug court thing. That's what it's about. But you're still a little jacked up. and you get jacked up about your family and that sort of thing, but that will jack people up,
Yes.
okay? So that's the reason that people cannot represent themselves, because it's like asking somebody what minor surgery is. Minor surgery on somebody else,
Yes, sir.
somebody else's kid. Visitation, with your visitation, and the fact that she willingly admits that the children still enjoy being with you. You know how much blessing that is for you, that after everything that's happened, that these children still want to be with you. You know why? Because children naturally love their parents even when they don't deserve to be loved. So what you need to do, rather than try to come and argue this yourself, is get along with it and let the lawyer work with Miss White and the mother to see if y'all can gradually expand these visitations back. And when you get finished with drug court, keep your job, things turn around, you chill a little bit and everything, that y'all can live your separate lives and co-parent these children. So I'm not gonna give you any more visitation today because I don't have a motion from you, but I'm not gonna take any of it away from you, okay?
Can I say one other thing
If
about
you
this?
want to, you're
With the
probably
article,
better off
they,
be not.
well, I mean, with the article, like they turned in for evidence a while ago.
Yeah.
I have blocked her, my family, her whole family. And in my opinion, they need to quit stalking me. I get comments, I get things.
What do you mean
all the-
stalk? What do you
Well,
mean stalk?
I have her blocked on every social media, Snapchat,
Well, here's the
everything.
thing about it.
Yet they keep,
Somebody sees something like that, I'd want to know if the father or mother of my child was putting something up there, especially if I was concerned about them anyway. So maybe a relative or somebody sees that and sends it over to them. It would concern me on whether my daughters or children were going to come over to see you if you're putting stuff up there like that. So I better not see any more of it. Just keep it to yourself, man.
one more thing.
Yeah,
It's just,
well, you're not helping yourself. but
no,
keep
this
on
is
going.
about our visitation, Your Honor. I know I'm not supposed to be within 1,000 foot of her. She's coming in early to our visitation and sitting in the parking lot, McDonald's, Majors. I don't want anything to be used against me. Can her aunt please inform her when her
Well,
visitation's
I
over?
want to tell you, if you're at the McDonald's and she pulls up out the parking lot, and I'm not gonna say anything about that, it's okay.
I just don't want charges against me. Your
Well,
Honor.
have you been pulled up McConnell? It's okay.
Like, I don't do anything. I sit there and I make it.
Okay, well, that's okay. Just don't worry about that.
Okay,
portion.
I just don't want to get myself-
Well, that's one thing that you don't have to worry about.
All right, thank you, Your
Okay.
Honor.
Okay, now you can go ahead and leave.
Okay.
And we'll you get a short order that the visitation as is will continue for 3 months, 3 months, okay? Okay, thank y'all very much.
You want me to put a review date or just say and it may be brought back?
The rule, let's come back on April the 11th. See if we top the order, okay? Hey, let's go off the record.